The case Fulton versus City of Philadelphia was argued before the U.S. Supreme Court on November the 4th, the day after our last election. At issue was the claim of a Catholic social service agency in Philadelphia that it has the right, based on the principle of its religious freedom written into the Constitution, it has the right to discriminate against same sex couples who are applying to be adoptive or foster care parents. The city of Philadelphia has required that foster care and adoption agencies agree not to discriminate against same sex couples because they are protected by the city's laws, the anti discrimination laws. So today, to help us understand this case, which has not yet been decided but has now been argued, and what its implications are, we have Professor Arthur Leonard. He is a professor at the New York Law School, and he first came to the law school in 1982. And at that time, only one state banned discrimination based on sexual orientation, and gay sex was illegal in half of the country. Only a handful of lawyers were actively litigating sexual orientation discrimination cases. Using the law to help win equality has been a guiding passion of Professor Leonard's, and he uses his role as a legal educator to constructively help shape the law. And he's also an educator. Over the past 30 years, he's written numerous articles on employment law, AIDS law, and lesbian gay law, including an influential law review article in 1985 on AIDS discrimination that helped form the nation's legal response to the AIDS epidemic. He's a frequent national spokesperson on sexual orientation law, an expert on the rapidly emerging area of gay family law, and he's also a contributing writer for Gay City News. You can read his analysis in Gay City News practically every edition. And that's a biweekly, comes out on Thursday, so take a look. And he's also written for several other lesbian and gay newspapers in New York City. So I want to say welcome, Art Leonard. Thank you so much for coming on our show again. We've had you on before.
I'm pleased to be here.
Okay, cool. So to begin, could we just get an idea from you of like where does this concept of a religious exemption fit into the U.S. law?
Okay.
It's basic to the Constitution, am I right?
Well, in the First Amendment of the Constitution, adopted in 1791, it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So this was a limitation in the original Constitution, or actually in the first set of amendments, the Bill of Rights, that Congress cannot abridge freedom, free exercise of religion, or prohibit the free exercise of religion. And this was only binding on Congress, on federal legislation, but the Supreme Court came to see it as being binding on the federal government generally. But then after the Civil War, the 14th Amendment was adopted, and the 14th Amendment was ultimately interpreted by the Supreme Court midway through the 20th century as expanding the scope of that ban on prohibiting free exercise of religion to the states, because the 14th Amendment says that the states may not deprive people of due process for law, and the court says that means that you can't take away or abridge people's fundamental rights, and they saw free exercise of religion as a fundamental right. All right, so if freedom of religion is a fundamental right, then the question arises, can the city of Philadelphia say to a Catholic social service agency that despite your religious objections to same-sex marriages, you must treat people who are in same-sex marriages the same as other people who are in marriages, and you can't say that these services that you're providing are only limited to heterosexual married couples. And this is just dealing with foster care, not adoption, what we're talking about here. And there is a case that was decided by the Supreme Court 30 years ago called Employment Division versus Smith, which I believe we were going to talk about as well,
So
in which in which the Supreme Court said that there are no religious exemptions from complying with state laws of general application that don't particularly target religion. So if a state or a city, for that matter, has a law of general application that you may not discriminate on a particular basis, there is no exemption for religious organizations from complying with that law. Now, if an organization is a church, obviously the city is not going to try to enforce on a church that they can't refuse to marry a same-sex couple or something like that, because the free exercise of religion is rather fundamental. But we're talking here about an agency that by contract with the city of Philadelphia was given the authority to evaluate prospective foster parents, to certify them as qualified, and then to make matches when the city referred children who needed foster parents. That's really what's at issue here. Now, at the time that this case arose, there were 30 different agencies in the city of Philadelphia that dealt with this process of evaluating foster parents. And it turned out that only 2 of them refused to deal with same-sex couples. One was a Protestant agency, and the other one was a Catholic agency, Catholic Social Services. And a local newspaper heard about someone being turned away at one of these agencies and decided to do an article about it. And they notified the city that they were going to be doing an article in the local newspaper claiming that these agencies were in violation of the city's non-discrimination law. And so the city agency that was in charge of overseeing the foster care process, the Children and Family Services Agency, they get in touch with Catholic Social Services and with the other religious agency, and they say, is this true that you won't deal with same-sex couples who are married?
Do you think they were really surprised?
No, I don't think they were
They knew,
surprised.
I'm sure they knew.
But no one had ever
No?
complained to them before. You know, these agencies, normally they respond to complaints. So no one had ever complained to them. And I think most same-sex couples who wanted to be foster parents, when there are so many agencies in the city, why would they go to Catholic Social Services anyway? And Catholic Social Services, their response to the city was, yes, we will not evaluate same-sex couples because it's against our religion to say that they're qualified to be foster parents. We don't approve of same-sex marriage. We don't approve of homosexuality, et cetera, et cetera. But you know what? We've never had a same-sex couple apply to us. I mean, you know, the cardinal has made it very clear that Catholic institutions aren't going to honor same-sex marriages. So, you know, it would be futile. And besides,
Right.
if they did, we would refer them to another agency. So their position is that any same-sex couple, any married same-sex couple that will be qualified has plenty of opportunities to get certified and matched. They don't have to go to Catholic Social Services. And this came up in the oral argument. So the issue under the First Amendment, if the First Amendment applies to this situation, the issue would be whether the city has a compelling justification for requiring Catholic Social Services to deal with same-sex couples. But Employment Division versus Smith would say, because the non-discrimination requirement is across the board, it wasn't adopted to target religious organizations in particular, it's applied to everybody. Anybody who has a contract with the city can't discriminate. It isn't whether you're a religious organization, a non-religious organization, or which religion. It's just an across the board. It's a rule of general application. So under Employment Division versus Smith, there's no exemption. What is significant now is that at least 4 members of the Supreme Court have at various times over the past few years said that they would like the court to re-examine that old precedent of Employment Division versus Smith. They don't like it.
And that old case,
that
I'm
old
sorry,
case, yeah.
that old case you said was decided by a very the decision was written by a very conservative
Yeah, by
Supreme Court.
Scalia. Antonin
Right.
Scalia, the hero of Justice Gorsuch and Justice Kavanaugh. You know, these people,
Yes,
they
yes.
worship Scalia. Also, our newest justice, Justice Barrett, is a Scalia
But what
acolyte.
did Scalia say? What did he
Scalia,
say? Why
he
could, yeah.
basically said that if any individual or organization could refuse to comply with the general law because of their religious beliefs, that would be the way to anarchy. That would be it would be chaos. Every individual would decide whether they're going to comply with the law, and they say it's because of my religious beliefs. And the traditional view of the Supreme Court is we don't inquire into the validity of someone's religious belief. They don't have to say, oh, there is like this church or that church that has a doctrine that I'm following. You can be the church of one person. You can have your own set of religious beliefs. So he said basically, look, we can't have this. We can't have this. If it's a law of general application that everyone has to comply with, you've got to comply with it. And the city certainly has the right to establish a policy that people who are legally married may not be distinguished based on whether it's a different sex or a same-sex marriage, because the Supreme Court said in 2015 in the Obergefell case that same-sex couples have a right to marry, and their marriages are entitled to be treated exactly the same as any other marriage, as a matter of equal protection and due process.
So
So,
how does this differ from the Masterpiece Cake Shop case?
okay, the
Because
Masterpiece
that was
Cake Shop
another,
case.
yeah, go ahead.
Right, that presented a similar issue, right? So you have a baker who refuses to bake a cake for a same-sex couple. That case arose before the Obergefell case was decided by the Supreme Court. It arose at a time where it wasn't clear as a matter of constitutional law that same-sex couples had a right to marry. Some states had allowed same-sex marriages, some states didn't. Colorado at the time didn't. This same-sex couple who lived near Denver, they went out of state to get married, and they figured when we come back, we'll have the big party here in Denver, and we'll go to a baker, Masterpiece Cake Shop, which was locally famous for their very artistically designed wedding cakes, and we'll order a wedding cake. And they go into the store, and the baker says, oh, I don't do same-sex marriages. So I don't believe in it. It's against my religion. And he said, there are plenty of other cake shops that'll do a cake for you, but I'm not going to design one, for a same-sex marriage. So they filed a charge against him with the Colorado Human Rights Commission, and they won. And the Baker appealed the decision to the state courts, and the state court upheld the commission. And so he petitioned to the U.S. Supreme Court, which agreed to hear the case. And what happened in the Supreme Court, he wanted to establish that he had a First Amendment right to refuse to make the cake. But the Supreme Court didn't decide the case on that basis. There was evidence that comments were made by the members of the Colorado Civil Rights Commission while his case was pending, which the court said showed that they were hostile to his religious beliefs. And they said he was entitled to have his case decided by judges who were not hostile to his religious beliefs. And that was the basis on which the court said they were going to have to reverse the lower court ruling. So they never rendered a judgment directly on whether he had a First Amendment right. But Justice Kennedy, who wrote the decision for the court, he said, but we have in the past said that individual religious views may not be a basis for refusing to comply with anti-discrimination laws. And that goes all the way back to the 1960s, when it became illegal to discriminate on the basis of race in a place of public accommodation. And a restaurant said, well, we don't believe in racial integration. It's against our religion. We're not going to serve people of color and white people in our restaurant at the same time, or we're not going to seat them in the same area or whatever. And they were sued on that for discrimination, and they tried to raise their First Amendment claim, and the court said no. The court said, you don't have a right because of your individual religious beliefs. You're running a business, and your business has to operate on non-discrimination principles the same as any other business that provides services and goods to the public. And so this, and that predates Employment Division versus Smith by several decades. So although Employment Division versus Smith is the case that's usually cited on this general principle, it was not totally out of the blue. I mean, there were prior cases that made a similar point. But what we have now is we have 4 members of the court, Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh, who have indicated in the past that they were interested in having the court revisit this issue of whether people can raise a First Amendment claim if they have a religious reason for not complying with the law. And So they probably are the four members of the court who voted to grant review in the Fulton case.
Because
But now
there were
they
only
have an
8
ally.
members at that time.
Yeah, there were only 8 members at the time. Now they have an ally, possibly Justice Amy Coney Barrett, who is, if anything, as firm and equal a freedom of religion advocate as any member of the court that you can imagine. So they might get a fifth vote from her. And if Employment Division versus Smith is overruled, that means that people with religious objections have an exemption from complying with the law unless the state can show, or the government can show, that it has a compelling interest that can only be achieved by applying the law to them. And if they overturn Employment Division versus Smith in this case, that doesn't necessarily mean that the city of Philadelphia loses. But they would have to conclude for the city of Philadelphia to win that it had a compelling interest to prohibit discrimination against same-sex couples, which could only be achieved by requiring Catholic Social Services to evaluate them and certify them as qualified to be foster parents. And I think Catholic Social Services has a pretty decent argument that in a city with 30 agencies that provide this service, the fact that one or two of them don't for same-sex couples doesn't create a compelling justification for the state to go after them. If they're very polite to people. When people apply, they don't say, "Oh, you're an abomination," etc. They say, "Oh, we don't handle those. We'll refer you to another agency." Now, we have a similar case pending in New York at present involving an agency in upstate New York that also refuses to deal with same-sex couples. And in that case, no one had made a complaint against them. The agency had been around for more than 50 years. Same-sex couples had never applied because the name of the agency, which eludes me at the moment, but it's a religious name. So the same-sex couple in upstate New York that wants to be foster parents, there are other agencies they can go to. They're not going to go to this agency. And this agency has never had an application. But the state department that regulates adoptions and foster care decided to do an audit of all the agencies. And they asked them to provide a copy of their policies. And when they saw that this agency had a policy of only dealing with heterosexually married couples, they said, "Oh, that violates New York state law." And they got into this big argument, and it turned into a lawsuit. And so that case is still pending. A trial judge at first, that was upstate. I think it was in Syracuse.
Yeah. So it would go through the New York state courts.
Well, it's in the federal district court upstate.
Oh, it is.
And at first, the judge, they had asked for an injunction against against the state agency. And the trial judge refused the injunction, and they went up to the Second Circuit, which is the federal court of appeals that has jurisdiction over New York and Connecticut and Vermont. And the Second Circuit reversed and sent it back and said, no, the judge should consider whether they should get an injunction because we think that they may have a valid claim. And part of the reason they said that was because of Masterpiece Cake Shop. They said that there was, in the correspondence back and forth between the state agency and this religious agency, there were statements that might show hostility to their religion. So based on Masterpiece Cake Shop, maybe they have a case.
Yeah. And I just want to move to the general question of what do you see, what's the perspective for the rights of LGBTIQ people with the Supreme Court that we now have in the United States? What's your,
I think there is a significant danger. There is a significant danger that the important protection that we won under Title VII of the Civil Rights Act in June in the Bostock case, that was a 6-3 ruling that the Civil Rights Act of 1964, which prohibits sex discrimination, also prohibits discrimination against LGBT people based on sexual orientation or transgender status. And that's safe for now because 5 of the 6 members of the court who participated in the majority in that ruling are still there. So that's safe as a precedent for the moment. But a big exception can be carved into it if they get rid of Employment Division versus Smith And if they adopt a similar view under the Civil Rights Restoration Act, which was a statute that was passed by Congress after Employment Division versus Smith, creating an exception under federal statutes for people who claim that their free exercise of religion is burdened by the application of a federal law. So, there was a big question opened up under Title VII, whether religious objectors may be able to discriminate against gay people and under what circumstances, and also more broadly, if Employment Division versus Smith is gone, then people are going to start raising First Amendment claims in other contexts, like businesses, like providers of services. We have a dispute going on with the U.S. Department of Housing regarding homeless shelters and homeless shelters that are single-sex facilities, excluding trans people. And the current administration wants to allow them to be excluded, whether they would, whether a religiously affiliated homeless shelter can say, well, we have religious objections to transgender status and or to housing a transgender woman at a women's homeless shelter. And they may say that we should have a religious exemption if there is a local law that would require it. So, there are many things that could happen.
Yeah, it sounds like things are the balance is kind of shifting, and we really don't know what's about to come down on us. So,
yeah,
even
well,
with
the change of administration. See, the problem is, if there is a vacancy in the Supreme Court over the next 4 years, while Joe Biden is president, but the Senate is in the control of the Republicans, they could block anyone he tries to appoint if they have control of the Senate, which is why the runoff election in Georgia on January 5th is so crucial. 2 seats are up, 2 incumbents.
Yeah, we know.
You've talked about this issue. If the Democrats win control of the Senate, since the filibuster rule has been abolished for Supreme Court appointments, then Biden can appoint. And if the Democrats hang together, they can confirm whoever Biden appoints. Now, the oldest judge on the court at this point is Justice Breyer, a progressive Democrat who was appointed by Bill Clinton. The next oldest is Clarence Thomas, who is the most conservative member of the court. Normally, in a first term, a president gets 1 or 2 Supreme Court appointments. So, unless something happens to one of the less senior judges, the ones most likely to go off the court over the next 4 years would be Breyer and Thomas. So who knows? Biden might get 2 appointments. We might be able to tip the balance back on the Supreme Court. But as of now, there is a conservative majority there. It's been reinforced by Barrett. It's a 6-3 majority now. Chief Justice Roberts is a bit of a swing vote at times, but unpredictably so. As Justice Kennedy was sort of unpredictably so. So as far as gay rights go, we've been working with the Republican majority on the Supreme Court for almost 2 generations now. The point is that some of those Republican appointees were sympathetic on gay issues, like Justice Souter, like Justice Kennedy, sometimes Justice O'Connor. Sometimes we would get their votes in cases. But basically, the Democrats have not had a majority on the Supreme Court since, I guess, the 1980s.
So Art Leonard from the New York Law School and also a very important writer for Gay City News, thank you so much for coming on our show. It's really been very helpful, and we'll be watching the courts and getting back to you as things start to develop.
Okay.
So, stay safe. Bye.
You too. Bye-bye.